Sorry I ran out of there so quick.
I told her, get off 7 and get to 17.
I heard you got
Good luck if she can.
That's what she said. I'm going to try.
Yes, good
I
luck.
don't know.
Yeah, good luck.
It was like, if you can get to 17,
Yeah, she
you
could.
should be all right.
Yeah,
She was like,
good
let's
luck.
see, because
Yeah,
Nikki, go, because Charles is waiting, and then come back.
they let her out. Good morning.
Okay, let's go on the record in the state of Florida versus Medina. The state defense, Mr. Medina, are present, just so the record is clear. We are running about an hour and a half late because I-95 was shut down today. Many of our jurors who we have been in contact with are running late. So we are presently down one juror, but she is about 10 minutes away. My judicial assistant is on the phone with her. When she gets here, I'm going to give her a few moments to defrazzle. We all know that being in a car for over 2 hours can be a daunting experience. So we'll give her a few moments to unwind and relax. And I've asked the jurors if, Jose to ask the jurors if they would like some coffee, and Nikki will prepare them coffee if they wish. Let's take up from the state any motions.
Yes, Judge, a few things. First of all, the court asked me to speak with someone at NMS Labs this morning.
Yes.
I was put in touch by Mr. Padilla with a woman named Janine, who I spoke with, who informed me that if the defense was willing to pay an expedited fee, they could get the documents here into a Dropbox for us to view by Thursday evening. She also asked me, since the court asked me to ask her about the procedure for all of this, she informed me that she was not asked about a litigation packet by the defense until the end of last week. So I said to her, well, if you would have been asked sooner, could you have gotten it sooner than this Thursday? And she said to me, yes, we work on it on an expedited basis. I bring that up only because I raised the issue of the data to this court. We finished Dr. Logan's deposition, if the court recalls, in the middle of jury selection on Friday, November the 6th, during lunchtime. And I reported back to the court that afternoon, if not Monday morning, but I believe that afternoon, that in fact we had finished the depot, and that barring him not having files, including this one, for me to question him about, we had finished, and that in fact I would want to talk to him about it if I can please get the raw data, but that I wouldn't need to redepose him. I would just need to speak to him outside. And so I just bring that to the court's attention that I raised that on Friday, November 6th. She informed me she got this request at the end of last week. She did send me a list of basically what is included in the litigation packet, so I could at least start asking my experts if they need anything further. And as of 9:53, when I hung up with her, she informed me she was still waiting for confirmation from defense counsel if, in fact, they were going to pay the expedited fee, so that she could start preparing the packet, because that still had not been done. That's what I'm told.
Defense?
Good morning, Judge. Just so I can lay the appropriate record. I know I've laid it in the past, so I just want to go ahead and lay it again. The state has had notice of these results for over a year and a half. They have chosen to now, at the beginning of trial, through an oral tennis motion to compel, ask for raw data on a simple drug test that's done through NMS Labs. We have complied with every request that the court has made. We've shown the court emails that we've sent to NMS Labs, which include an email that we sent last week in the middle of the week asking for the raw data.
All I've received, just for the record, is a response from NMS Labs that was sent on Friday indicating it would take 2 to 4 weeks.
Okay. We can forward you our communication with them if the court requires that. We spoke to them this morning. We spoke to someone that could, in essence, try to get us the expedited package. We're in the process of having to pay the egregious expedition fee, which my client has to pay out of his own pocket. This is a private case. And so we're going to get that done, Judge, and we're going to get the raw data by Thursday night.
So, Judge, is defense putting on the record that they haven't spoken with NMS Labs and have confirmed that they will pay the fee and that is in the process of being done? Because she indicated to me that in order for us to get it Thursday night, she would have to start working on it today.
We spoke to her. Me and Mr. Padilla spoke to her this morning. For the process to work, they have to send us a credit card authorization email. Have we gotten it yet?
I got it. I gave it to my assistant, and she's filling it out, and I just sent her another
So
email
what we'll
saying-
do is, the defense has made an announcement to the court that they are intending on doing that. We'll take it back up after the lunch break. To find out whether that has been confirmed with NMS Labs.
Okay.
Okay? Anything else from the state this morning?
Yes, Judge. We received 2 motions this morning around 7 a.m. One was a motion in limine as to the autopsy report, and that the state of Florida, well, it's entitled that we shouldn't be allowed to put it in evidence, and then at the end there's something about not to use and or mention the autopsy report. So I'm not exactly sure what they're asking. I can tell the court, Judge, that the state is not planning on putting the autopsy report into evidence, the report itself. Needless to say, Dr. Liu will be referring to the autopsy report that she co-authored with Dr. Johnson. She is not a substitute ME. She was training Dr. Johnson and was with Dr. Johnson at the scene, doing the autopsy, consulting with her. She was right there. So she's not a substitute ME for purposes of the case law that says that a substitute ME can't refer to a document as hearsay. She was actually the ME with Dr. Johnson. Her name appears on the ME report. So I'm not sure what they're asking, but as far as the actual report going into evidence, Judge, we are not putting the report into evidence.
Okay, with that being said, defense, do you still wish to be heard on the motion in limine that was filed this morning as to the autopsy report?
Judge, it's my understanding, based on when we deposed Emma Liu, that she didn't have a recollection of co-authoring this report. That's my recollection. She didn't have a recollection as to her involvement in this case other than signing off. When I asked her, page 5, line 4, who actually did the physical autopsy of the decedent, the answer was Dr. Dana Johnson.
Okay, so what is this defense arguing at this point on this motion?
Well, Judge, if Ms. Johnson did the autopsy, and it's our position that Dr. Emma Liu was a substitute ME, that we're moving to strike the actual autopsy report, and we're moving to instruct that we're asking for an instruction from the court to restrict the prosecution from being able to make reference to the autopsy report, since Dana Johnson is the author of the autopsy report.
Okay, I understand that the defense is relying on Rosario v. State, which is a Florida 50CA case from 2015.
Correct.
However, the court is bound by BANMAH, B-A-N-M-A-H versus State, 87 Southern 3rd, 101. So respectfully, the defense's motion will be denied. That is a 3rd District Court of Appeals case from 2012. So the court is bound by the 3rd District's pronouncement, and the 50CA clearly states in their opinion, which I was able to review extremely briefly, they recognize the conflict with BANMAH, but this court is bound.
Correct, Judge. I respectfully will preserve our objection to that.
So no.
Thank you, Judge.
Okay, and I also see that there's been a motion to introduce child hearsay testimony. I'd like to put this on the back burner until we get to the defense's case.
Judge, we were going to ask for some more time to address it as well, so that's perfect.
Okay, so
Thank
yes,
you.
I think it's a little premature.
Excellent.
Okay, anything from the defense?
Yes, Judge.
Thank you for covering for me. Appreciate it. Okay, from the defense, thank you.
Judge, there are a few matters. Obviously, the court's privy to the issues that we're having with regards to a state and defense witness, Kelly Berry, who indicated that she had a doctor's note that would prevent her from being able to travel. The court, the defense, and the prosecution have gone to extreme measures to facilitate having her testimony be provided via satellite. I asked Mr. Dunn this morning, because here's the thing, Judge, as the court knows, we've asked the prosecution how many more witnesses they have left, purely from a scheduling standpoint. I spoke to Mr. Dunn this morning. It now appears that Ms. Berry may have some collateral medical issues. I'm not sure exactly what it is because I didn't speak to Ms. Berry. I haven't spoken to her physician. I wanted to know from a scheduling standpoint if he was going to call it. If not, then we needed to take the horse by the reins and control that issue. But he did indicate that he had conversations with either Ms. Berry, I don't know if it was her physician, so I'd like the court to inquire. I know that he's in a position to discuss this.
Mr. Dunn, can you update the court as to what's happening with Ms. Berry?
Of course, Judge. Well, first, the state hasn't made a firm decision on its end as to whether we would call her. However, we are aware that the defense has listed her regardless. We are maintaining communications with Ms. Berry in terms of remaining up to date on her medical situation. As of now, Ms. Klein and I just spoke with her yesterday. We still believe she could be in a position to testify. If that changes and she tells us she cannot even appear via satellite, which she has not told us yet, but we're monitoring her constantly. We will advise the court.
Can we go sidebar? I don't want to put her medical condition.
Thank you.
Part of the event.
Okay. I'll wait.
Okay. Any other issues from the defense?
Yes, Judge.
We'll wait for Rand. Thank you.
Judge, there is
Yes.
one final issue with regards to the toxicology work done in this case. I know that I know we asked, I think that we may have asked with a slew of other matters, and I know the prosecution has provided us with the entire file with regards to the DNA analysis, but what I'm asking the court to do, and I'm moving to do I'm moving to compel, if they could provide us with the levels of detection in the urinalysis report, which is the gas chromatography, mass spectrometer results are, with regards specifically to the metabolites or derivatives of alpha PVP. We don't have that, and it's something that we asked for. At some point, they kind of got lost in the mix when we were asking for some DNA work. So if we could see if they have...
I thought that the determination was that there were no metabolites present.
Well, this is, right, it's called library matching, Judge. So when they tested the urine, what they do is they do an initial urinalysis to see if there's a marker that goes off, and then they do a blood test specifically for whatever gets hit in library matching. Based on Dr. Boland's testimony, they did library matching as an initial phase when they took the decedent's urine and did the urinalysis through their gas chromatography mass spectrometer analysis. We want to know whatever raw data they have with the library matching, specifically what the levels of detection are for alpha PVP or what any of its metabolites.
Kate, would you like to be
I'm sorry, what was the last thing, the level of detection and what?
The level of detection for alpha PVP or any of its metabolites.
Can you do me a favor? Write that down.
I'll write it all down.
Let the state look at it, speak to their expert, and we'll hear from the state after lunch.
And I also want to just check all of our old discoveries, because I believe what we have was already sent, but I will double check Judge
Okay.
at lunch.
And what the defense is requesting is a mouthful, so I want to make sure that you are fully apprised, state,
Thank you.
of what they're specifically requesting.
Thank you, Judge.
Okay? You can put it on a sticky, just give it to the state, so it doesn't need to be formally. Okay, so all are here, ready to go. With that being said, State, do you want to bring well, first of all, State, anything else before the jury comes down?
No.
Defense, anything else before the jury comes down?
Judge, we're moving to strike. We're going to ask the court to reconsider its previous ruling on allowing the informant, well, I don't know how to characterize him, but the witness that provided the government with alleged information with regards to my client at the 11th hour. I know that they got it at the 11th hour. They did their due diligence. But we'd ask the court to reconsider striking this informant, specifically because we believe during jury selection we didn't have the ability to inquire and voir dire with regards to that specific issue. I know the court's previously ruled Mr. Medina has asked me to re-raise this issue, and obviously when we do ask for the court to consider all our previous objections, that's included, but Mr. Medina has asked me to specifically raise this issue, and respectfully, Judge, we'd ask the court to reconsider that ruling.
I don't think that motion's actually been made at this point, but is the state even intending on calling this witness that you're aware of right now?
Judge, we can't rule it out. I think Ms. Klein represented to the court in good faith that it's not likely. I believe that was the last thing we
That was
stated
the
to the
last
court.
thing.
Correct.
I don't think there was ever a motion to strike him before. The defense has deposed him at this point. We produced him at the state attorney's office, so he has been deposed.
Okay, so let us do this. What we're going to do is we'll put this one on the back burner as well. If the state ends up calling them before you call them, ask for a recess, we'll take it up and we'll do a Richardson hearing if the witness is called. Okay, but I will also state for the record that I do not believe I ruled on a motion to strike. The last time we discussed it, it was up in the air, and we will leave it up in the air until it becomes a relevant issue.
Thank you, Judge. Thank you,
Thank you.
For informing us, and also, Judge, for the record, I'm renewing all my previous objections, Judge.
Okay.
Thank you, Judge.
So everybody take a seat, get comfortable, and as soon as the jury is downstairs, which I believe they will be in a moment, we will begin. Bless you.
May I run to the restroom, Judge?
Okay, very quickly.
Could you just come to that bar?
Do we need?
No.
Okay.
You may be seated.
Okay, for the record, the State Defense, Mr. Medina, and all of our jurors are accounted for. Okay, so this morning I got into work after being in my car for 2 hours, and my JA asked me, did you get a haircut? And I said, no, I've been pulling at my hair because I have been in traffic for 2 hours. I know some of us were stuck on the bus. I know some of us got stuck in traffic. Take a deep breath, folks. Welcome to my neck. Okay, but I thank you all for your commitment, the state, the defense, Mr. Medina, my court staff, and quite frankly, the community. We all thank you for your commitment to this case, even when you're stuck in traffic for 2 hours. So thank you very much. So before I turn it back over to the state, let me ask the members of the jury over our long weekend, did you all follow my instructions as always? Yes. Wonderful. Detective, will you confirm for me that you are still under oath, having sworn or affirmed to tell the truth and nothing but the truth?
Yes.
Mr. Dunn, when he is ready, you may continue with your direct interview.
Thank you, Your Honor. Good morning, Detective.
Good morning, sir.
Let us continue where we left off if we could. I believe we finished just discussing Mr. Medina's statement, so let's move into Mr. Medina himself. During your investigation of this matter, was Mr. Medina, the defendant, photographed?
Yes, he was.
How many times total was he photographed by the police department?
He was photographed by members of our crime scene unit twice.
Were you present during both times?
Yes, I was.
And did you observe any marks or injuries or anything physical on his body during the photographing of the defendant, either the day of his arrest or later?
Yes, we did. We noted 2 areas that the defendant pointed out to us on the initial day that we met with him and subsequently on the second time as well.
Okay. And how many days after his arrest was he photographed the second time?
I believe it was 8 days.
Were Mr. Medina's clothes collected at the police station?
Yes, they were.
Did his clothes have any damage to them that you observed?
Not that I recall.
And who took custody of the clothing?
The clothing is impounded by our crime scene unit that responded there to process the defendant.
Your Honor, for the record, I am going to show defense counsel and the detective what have been marked for identification. That states 8L, 8N, 8O, 8Q, 8R, 8T, and 8U for identification. Approach the witness, Your Honor. Detective, handing you the exhibit that I just announced into the record, can you tell me you recognize those?
Yes, I do.
Okay, and how do you recognize those?
These are the photographs, or some of the photographs that were taken of Mr. Medina at our homicide bureau on August the 8th, 2013.
Are these fairly and accurate depict how he appeared on that day?
Yes, it is.
Your Honor, this time the statement moving the aforementioned exhibits into evidence.
Any objection?
Without objection.
So noted.
8U will become state exhibit number 153. 8T will become state exhibit number 154. 8R will become state exhibit number 155. 8Q will become state exhibit number 156. 8O will become state exhibit number 157. 8N will become state exhibit number 158. And 8L will become state exhibit number 159.
Ask the detective to sit down.
He may.
photos taken of him without clothing on to see if he had any marks or injuries under his clothing that weren't visible in those pictures.
Yes, there were.
Let's take a look at those. Your Honor, I'm going to show counsel at this time states 8W, 8X, 8Y, 9A, 9B, 9C, and 9D for identification.
While they're doing that, we'll remind everybody in the courtroom, please make sure that your cell phones are off. You may.
Detective, showing me the next set of photographs. Will you please tell me to recognize those as well, please?
Yes, I do.
And do those fairly and accurately depict the defendant how he appeared now without some of his clothing?
That's correct.
Your Honor, at this time the state moves the aforementioned exhibits evidence.
Any objection?
Without objection.
So noted.
State Exhibit 9D will become State Exhibit 160. 9C will become State Exhibit number 161. 9B will become State Exhibit number 162. 9A will become State Exhibit number 163. 8Y will become State Exhibit number 164. 8X will become State Exhibit number 165. 8W will become State Exhibit number 166.
Thank you. I have to step down one time to be about it.
You may.
Detective, beginning with what's been admitted in States 166. In evidence.
This is a front shot of the defendant without his shirt on, but still wearing his jeans.
And 165 in evidence.
165 is going to show you a rear shot of the defendant without his shirt.
164 in evidence.
164 is the front shot of the defendant wearing his shirt and jeans.
And again, was there anything observed on his lower extremity and injuries or marks or anything like that?
No.
163 in evidence.
163 is an image of the defendant's hands in the open position. Will allow us to look at both sides.
And 162 in evidence.
162 is the top of his hands, similar photograph.
161 in evidence.
161 was a shot of his upper chest. It was one of the areas that we identified towards his had an issue during the
Can you point to which area or you recall which area you specifically pointed out to us he had an issue or something wrong with him?
The defendant showed us this area right here. He said that this was the area that was bothering him. So we made sure we got photos.
For the record, there's some redness apparent there.
Yeah, there's a little redness area right here.
And for the record, that's the which side of his chest?
West.
And lastly, number 160 in evidence, what was the which area of the body?
It's going to be the left upper arm in the outer area. This was another area that he pointed out to us in the injury that was also bothering him. So we took a photograph of that as well. You can see some slight redness in between the two sets of tattoos. Just to the, I would say, closer to the front area.
Now, Detective, you mentioned another set of photos that were taken about 8 days later, correct?
That's correct.
And for the record, Your Honor, I'm showing defense counsel what have been marked as states 8F, 8G, 8H, 8I, 8J, and 8K for identification. the witness.
You may.
Detective showing you the aforementioned exhibit. Can you please tell me if you recognize this as well? Yes. And are those some of the photos you referred to earlier that were taken about 8 days post-arrest?
That's correct.
And do you see how they accurately depict how the defendant appeared on that day?
Yes, they did.
All right, thank you. Your Honor, the state moves those into evidence at this
Any
time.
objection?
Judge, other than our previous objections, no, Judge.
So noted, and they will be moved in.
8K will become State Exhibit number 167. 8J will become State Exhibit number 168. 8I will become State Exhibit number 169. 8H will become State Exhibit number 170.
What, 170? You said 101, but you meant
170, Judge.
Okay, just making sure.
8G will become State Exhibit number 171. 8F will become State Exhibit number 172.
Thank you.
Your Honor, may I have the witness sit down one last time?
You may.
Again, the reports in evidence is 172.
These photographs, this particular photograph is taken of the defendant's front upper body area and left shirt.
And 171 in evidence.
This is a closer photograph of the same upper body area as the photograph of AJK.
And 170 in evidence.
This is the left side of the victim's body, showing his upper arm. The previous photograph, the photograph of AJK's wearing.
And 169 in evidence.
169 is a close-up, it's zoomed in with a measuring stick. You have a good accurate depiction of how large the area is. Of his outer left arm area, which he previously showed here.
And what exactly were you attempting or what crimes did you commit with these photographs?
Perhaps he's trying to take a photograph of the discovery that's right in the general center area. The photograph is not really large.
And 168 in evidence.
168 is just a downward photograph. It's slightly to the front of the defendant's arm. It's still the same area.
And 167 in evidence.
There was a small mark that the defendant pointed out to us.
Do you remember where this mark was? Is this something specifically you noticed?
It was something in the photograph.
And you can actually Now, did anything particular or unusual occur while you were photographing the defendant during that second set, 8 days subsequent to his arrest?
Yes, when we arrived at the jail to photograph him, his attorney was present. He started agitating an area of his chest. I immediately pointed it out to the crime scene detective as well as defense counsel. A little agitation to the area of his chest. We also photographed that as well, but we also noted that he did that in our presence as well.
When you say agitated, what specifically did the defendant do?
When I noticed him, he was grabbing his skin, sort of just grabbing it and moving it around, and we immediately photographed that and made a note of that.
Now, did any of the marks that you observed of the defendant's body, either the day of his arrest or later, 8 days later, appear to you to be of a life-threatening nature?
No.
Now, during the defendant's statement, which you testified about on Friday, he claimed that Jennifer Alfonso pulled a knife on him, correct?
That's correct.
Did you observe any cuts or lacerations to the defendant's hands, either the day of his arrest or 8 days later?
No.
Now, following your interview with the defendant, Where did you respond to next in terms of your work in this investigation?
After we completed our interview with the defendant, there's some things we need to do at the office. We went ahead and completed those things, and once he was being transported to jail, my partner and I immediately responded back to the crime scene, located at 5555 Southwest 67th Avenue.
And did you have occasion to enter the scene?
Yes, I did.
When you got there, was it still being processed by crime scene?
Yes, it was.
Who was the homicide detective on your team who was assigned to handle the scene of the homicide?
Detective Maria Medeiros. I assigned her initially as the scene and body portion of the investigation.
And was she still there working on that when you arrived?
Yes, she was.
And were Detective Medeiros and the crime scene officers able to fill you in on what they had been doing during the hours that you were interviewing Mr. Medina?
Yes, they were.
Now, while you were there, did you have occasion to notice the surveillance cameras set up inside and outside of this house?
Yes, we did.
Where did you notice cameras?
There was a camera by the exit of the front door, above the front door. There were several cameras inside the house. There was one right outside the kitchen, and I believe there was one upstairs in the hallway on the second floor.
And were crime scene able to locate the DVR equipment that were attached to those cameras?
Yes, they were.
Was that done prior to your arrival?
Yes, it was.
Do you know whether those DVRs were ultimately collected into evidence?
Yes, they were.
Did you later have a chance to view the footage?
Yes.
And did it appear that there was footage from the day of the homicide on those cameras?
Yes, there was.
Do you know if the time stamp on the video was accurate?
It was not.
What was it off by?
It was 3 hours and 11 minutes.
Slow or fast?
Slow. So actual time, you have to subtract 3 hours and 11 minutes.
Who within your department actually was put in charge of recovering the video from the day of the homicide out of those DVRs?
We have a video forensics unit that works out of our Homeland Security Bureau. They're tasked with retrieving any video that we have of DVRs and things like that. The detective that was assigned to retrieve the video from these particular DVRs was Detective Juan Luan.
And was Detective Arano able to ultimately provide you with a copy of the DVD reference, whatever he was able to extract?
Yes, he was.
Now, with respect to going back to the issue what Mr. Medina said about having a knife pulled on him, did you have a chance to view any knives located in close proximity to Ms. Alfonso's body?
Yes.
And were any of those knives recovered?
There was one knife that was recovered from a kitchen drawer.
Now, in the course of your investigation, did you have occasion to view any videos that the defendant had uploaded to YouTube?
Yes, I did.
And what particular videos did you view that you felt might be relevant to your investigation?
There were several videos of boxing. There were several videos of...
Judge, I'm going to object to this sidebar, please.
What's the sidebar? ladies and gentlemen, please disregard the last question and answer of the witness. Thank you. Mr. Decker, next question.
Thank you. With respect to the YouTube evidence that you may have found, which officer or detective was put in charge of retrieving anything from YouTube that might have been relevant to your investigation?
Detective David Olivo.
And was he able to provide you with the DVD of whatever he was able to recover?
Yes, he was.
Did you uncover anything in the course of your investigation reference Jennifer Alfonso having any boxing or fighting training?
No.
Did you impound any evidence from the medical examiner in this case?
Yes, I did.
What did you impound?
I impounded projectiles. I believe it was also a DNA card and legal source.
Showing you what has been admitted into evidence, as states 144.
This is without objection.
So noted.
You recognize that package as the projectiles that you had recovered from the medical examiner. If you need to open it, you may do so.
You have a pair of gloves? Yes, this is my bag.
And when did you impound these projectiles from the medical examiner?
These were impounded, I believe, on August 11, 2013.
Thank you. You can put the bag back in the box and hand it to the clerk when you're done. Now, did you have a chance, detective, to impound Mr. Medina's cell phone?
Yes, I did.
From where and when did you impound his cell phone?
Do you mind if I refer my report from you?
Go right ahead. You look up when you're finished.
We impounded the phone on Friday, August 9th. In the evening, I responded to the defendant's aunt's house.
And his aunt's name?
Valerie Medina.
And was that the same aunt that he said he drove to her house after the shooting?
That's correct.
And did the Miami-Dade Police Department ultimately conduct a search of that phone?
Yes, we did.
Did Mr. Medina provide consent for that?
Yes, he did.
Showing defense counsel what has been marked as States 9J for identification. Detective showing you 9J for identification. Do you recognize that form?
Yes, I do.
How do you recognize it?
This is a Miami-Dade consent to search computer peripherals, mobile devices, related media phone that we have.
And did you sign that form?
Yes, I do.
Did Mr. Medina also sign it?
Yes, he did.
And what was
Detective, I will remind you to keep your voice raised, please.
Yes.
And what was Mr. Medina giving the police department permission to search on that form?
The content of the cellular phone.
And what kind of phone was it, for the record?
An iPhone?
Your Honor, at this time, the state moves 9J in evidence.
Any objection?
No, Judge.
So moved.
State exhibit number 173.
May I publish, Your Honor?
You can do.